quiet 6-3 that shifts power in America. Most Americans have no idea it even happened. There were no headlines, no political speeches, and no primetime coverage. But late last night, the Supreme Court issued a 6-3 emergency ruling that just altered the balance of power between citizens and their own government, and more than 600,000 people will feel the impact first. What comes next could affect every single American who banks, communicates, travels, or interacts with federal agencies. This isn't just another immigration case. This isn't just another privacy case. This is the Supreme Court stepping in and saying that temporary actually means temporary, that the Fourth Amendment still matters, and that administrative agencies and district judges don't get to quietly run the country in the shadows. For over a decade, the system operated backwards. District judges blocked immigration enforcement coast to coast, federal agencies launched surveillance programs without warrants, and bureaucrats extended temporary programs indefinitely, all without Congress voting on any of it. That era just ended. If you care about constitutional limits, privacy, executive power, immigration enforcement, or digital surveillance, you need to pay attention because what the court just did ties all of those together. Before we get into the details and the fallout, make sure you are subscribed so you don't miss the next major decision. These rulings are coming fast now. Section 1. What the Supreme Court just did. The court issued a 6-3 opinion holding that the federal government can end temporary protected programs without proving humanitarian justification to a federal judge. The court also held that federal agencies cannot use emergency status as a loophole to run surveillance operations indefinitely without warrants. This matters because for the last 12 to 15 years, temporary programs lasted decades. Surveillance programs lasted years. District judges overrode national policy. This ruling begins to unwind all three at once. This is a structural ruling. It removes unelected actors from decision-making loops and puts constitutional power back where it belongs. Congress makes the laws, the executive enforces them, and the courts interpret, not dictate, national policy. Section 2. Why 600,000 people are at the center of this. Temporary Protected Status, TPS, was created in 1990 to give short-term relief to migrants fleeing war or natural disaster. The program was designed to last 6 to 18 months, but bureaucratic extensions turned 18 months into 12-plus years for over 600,000 individuals, many from Venezuela and Haiti. When the last administration attempted to end TPS, activist groups sued in federal court and judges blocked the policy nationwide for years. What TPS shows is the pattern. Temporary becomes permanent. Bureaucracy becomes policy. Courts override Congress. TPS was never about immigration alone. It became a test case for whether federal judges or federal agencies could quietly run immigration policy without elections or legislation. Section 3. Judges took control. To understand why this ruling matters, you have to understand how immigration enforcement actually worked for the last decade. In theory, the executive branch controls immigration. In practice, a handful of federal judges ended up controlling it instead. Here's how it happened. Whenever DHS or the White House tried to change enforcement, activist groups would immediately sue in the Northern District of California. They weren't choosing that court randomly. They were choosing it because of its track record, and it worked. Two things followed every time: a nationwide injunction stopping enforcement everywhere. Years of appeals that kept the injunction in place. For millions of Americans, it seemed like immigration laws existed only on paper. Meanwhile, the people setting the rules weren't elected officials. They were district judges and appellate panels who never had to defend those decisions at the ballot box. The Supreme Court rolled back that entire strategy in a single ruling. They didn't just end one injunction. They ended the idea that one judge can veto national policy for the whole country. That's a major shift few analysts are acknowledging yet. Section 4. The surveillance link. While journalists were busy talking about TPS, the Supreme Court was talking about something much bigger: how the federal government has been using temporary emergencies to justify long-term surveillance programs. That's where FinCEN comes in, a small office inside the Treasury that most Americans have never heard of. After a financial crime spike in 2018, FinCEN launched what was supposed to be a 90-day emergency program. Instead, it quietly lasted 6 years. During those 6 years, the agency monitored 30 million bank transfers a month. No warrants were required. No probable cause was needed. And here's the part people miss: the vast majority of those transactions belonged to completely ordinary citizens. The algorithm didn't care if you were running a business, helping family, paying rent, or moving money between accounts. The court looked at that system and said, essentially, no. The Fourth Amendment didn't vanish just because the government found a faster way to collect data. That ruling reaches far beyond immigration. It forces the federal government to relearn warrant requirements for the digital age. Section 5. Privacy reset. For decades, the government used a simple argument to justify mass surveillance. If you share data with a bank or a tech company, you've voluntarily given it away, and therefore you no longer have privacy rights in it. That legal theory is called the third-party doctrine, and it dates all the way back to the 1970s, long before online banking. Smartphones, cloud storage, encrypted messaging, or financial algorithms existed. The Supreme Court has been slowly pushing against that logic in modern cases. In Carpenter, they said phone location data still requires a warrant. In Riley, they said police can't search your phone without a warrant. In Jones, they said GPS tracking triggers the Fourth Amendment. This new 6-3 ruling goes even further. It treats financial metadata, not just content, as something that still belongs to the person, not just the company that holds it. That matters because metadata reveals patterns: where you live, who you pay, how often you earn, and how you move money. In simple language, the court just moved the Fourth Amendment into the modern financial system. That means agencies don't get to collect first and justify later. They need probable cause up front, the same way the Constitution always intended. Section 6. The power shift nobody expected. For decades, two branches of government have been fighting for control over how temporary programs end. Congress writes the statutes. The executive enforces them, but federal courts, especially within the Ninth Circuit, began inserting themselves as gatekeepers who could extend programs indefinitely through injunctions and procedural delays. The Supreme Court's 6-3 ruling rejected that third-player model and restored the original constitutional flow of power. Key points. Temporary status ends when the statute or administration says it ends, not when a district judge disagrees. Courts cannot force extensions based on humanitarian policy arguments. Executive enforcement cannot be blocked indefinitely without statutory footing. To understand how big this is, compare it to DACA, created by executive memo, extended for years through injunctions, and then trapped in legal limbo because no branch had final say. TPS followed the same playbook, except this time the Supreme Court refused to let it become permanent by inertia. The ruling didn't just free 600,000 TPS recipients from uncertainty. It reasserted who actually governs the country and under what constitutional authority. That's a much bigger story than immigration alone. Section 7. Surveillance meets the Fourth Amendment. Most people didn't see the privacy angle coming, but legal scholars did. The same ruling that slapped down judicial extensions also took aim at bulk surveillance programs run through financial institutions, telecom companies, and border agencies. The Supreme Court signaled that sharing information with a bank or carrier does not erase Fourth Amendment protections, a major departure from how agencies have operated for 20-plus years. Supporting cases. Carpenter v. United States, 2018. Cell site data requires a warrant. United States v. Jones, 2012. GPS tracking is a search. Riley v. California, 2014. Cell phones are digital containers protected from warrantless search. Combined, those cases narrowed the old third-party doctrine, and this new ruling continues that trend by shutting the door on bulk financial surveillance through administrative subpoenas. Millions of Americans who have never committed a crime were being monitored because algorithms flagged unusual patterns. That pipeline now has to meet constitutional standards again, something privacy lawyers have begged for since the Snowden era. Section 8. The real winners and losers. It's easy to say 600,000 people benefited, but that understates the winners by an order of magnitude. The more immediate beneficiaries were winners? TPS recipients gaining clarity after years of uncertainty. Small business owners targeted by FinCEN financial sweeps. Ordinary Americans protected from warrantless data harvesting. But there are losers, too. Losers. Agencies that relied on emergency powers to bypass Congress. District judges who used injunctions as policy tools. Advocacy groups who forum shopped for sympathetic courts. Immigration advocates fear families will be separated. Privacy advocates fear agencies will find new loopholes. Legal scholars worry about chaos during the transition. The Supreme Court majority rejected those concerns and argued the real chaos was caused by allowing temporary programs to become permanent without accountability. Section 9. The election consequence. This ruling quietly resets American politics heading into 2026. For the first time in years, voters know the executive branch actually controls immigration enforcement again. Not district judges, not advocacy groups, not bureaucrats. It also places surveillance authority back where the Constitution intended. Congress must authorize and courts must supervise through warrants. Political implications. Elections now decide immigration enforcement policy. Congress can no longer outsource hard decisions to agencies. Privacy rules must be debated publicly instead of hidden in memos. Both parties lose a shield. For years, they could blame activist judges or unelected agencies for outcomes. Now they own those outcomes directly. In a country where immigration, privacy, and surveillance are top issues for independents, this ruling ensures those debates happen where they belong, in elections, not backrooms. Section 10. The legal dominoes ahead. The immediate TPS and FinCEN shifts are only the beginning. The constitutional logic of this ruling creates new openings for challenges to DACA extensions, same temporary to permanent problem, border device searches, Carpenter logic applies, bulk telecom metadata programs, post-Snowden architecture, administrative subpoenas, no warrant equals weak footing, Chevron deference cases, agencies overstepping statutory limits. Immigration lawyers already predict petitions challenging temporary protected status renewals for other countries. Privacy advocates anticipate new litigation against FinCEN, DEA, CBP, and DHS surveillance tools. Constitutional scholars believe this ruling accelerates the Supreme Court's multi-year campaign to recenter executive and legislative power. The baseline message is simple: no more constitutional loopholes disguised as emergency programs. A shift back to constitutional government. For years, Americans lived in a country governed by injunctions, agency memos, and surveillance architecture that nobody voted for. This ruling finally forced a reset. Temporary means temporary again. Warrants mean warrants again. Elections matter again. The broader lesson from the court: if government power expands without accountability, constitutional limits become suggestions. This ruling pushes those limits back into force. If you want grounded explanations of these major legal shifts, not headlines, not panic, not spin, make sure you're subscribed. Big Supreme Court decisions are coming fast, and the next one could reshape how your rights actually work in practice.